SJC-11392, Commonwealth v. Elan DeJesus.
Yeah.
Yes, counsel, good morning.
Morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. We're asking the Court this morning to reverse the order allowing the defendant to withdraw his guilty plea in this case. The Court has before it three different interpretations of what constitutes effective advice in these circumstances, and I'd like to go through each circumstance, beginning with the defendant's. The defendant argued below, and he argues to this Court, that in a case like this, counsel's duty is to advise the client that as a result of the conviction, they will be deported. That's incorrect, as both the Commonwealth and CPCS are in agreement on that point. It's incorrect because deportation or removal, whichever way you term it, is never a certainty. And it's never a certainty because there are a number of factors that go into the determination as to whether or not a person may be removed.
But you disagree with CPCS's approach because you say that the attorney here provided correct advice, and
Yes.
they say this advice was incorrect.
Yes, and I'd like to get to that point in a moment. I will return to that point in a moment because I don't think that the Commonwealth and the CPCS are that far off as to what constitutes effective advice in these circumstances. But what is certainly clear is that telling a client that they will be deported is incorrect advice. And it's incorrect advice based on the very language of the deportation statute, which says that if convicted of one of these types of offenses, in this case a drug offense or an aggravated felony, it makes the person deportable upon the order of the Attorney General. So it has to do necessarily with the discretion of the Attorney General, and that is, in and of itself, depends on a whole host of factors, including what the current administration aims in enforcing these immigration statutes.
And we know the current administration has taken various positions on what it will enforce and what it will not enforce.
Absolutely, which is different from what President Bush, the latter, he was focused on deporting people who are in the country illegally as opposed to people with criminal convictions. President Obama in this administration is focusing on people who have criminal convictions, although they make up about, I think, half of the overall total of deportations. So one of the other factors is the type of offense and the length of the sentence. In this case, the defendant pleaded guilty to a drug crime, which was had a sentence of less than 1 year. Because it's a drug crime at the time, with a sentence of less than 1 year, under the ICE or Department of Homeland Security, the discretionary advisories, this was a level 2 priority offense, which means it was less of a priority for removal than a level 1 offense. So there are a number of factors that go into the determination of whether or not Homeland Security, ICE agents, and the Attorney General are going to actually institute deportation proceedings against a particular individual. That's why the advice that counsel must tell a client that they will be deported is simply incorrect. Not only incorrect, it could produce a very adverse effect to the client.
Well, are we asking about whether or not what Judge Healy thought should have been said was incorrect, or whether or not what was provided was incorrect?
I think we're looking at what was provided was incorrect.
So even if Judge Healy was wrong about what should have been said, that doesn't answer the question of whether or not what was provided was adequate.
I agree with that. I think that's a question of law that this court should decide. Let's then turn to what was provided in this case. In this case, counsel was presented with an offer from the Commonwealth, a very favorable offer to his client. He also knew that Padilla had come out 3 months prior to the offer. He secured a continuance because there was a motion to suppress scheduled. He secured a continuance so that he can research the immigration issues. He contacted an immigration attorney, and he learned, based on his research and speaking with an immigration attorney, that by pleading guilty to this offense, this defendant would become deportable. He therefore advised the defendant that as a result of pleading guilty, you are now eligible for deportation. You have satisfied the condition that makes you eligible for deportation. You face deportation. You are subject to the ramifications of deportation. And that is advice, excuse me?
All three things.
He said all three of those things, and they're in
Over
the-
time.
Yes, yes, on several different occasions. On several different occasions,
Not
he
all at
advised the client of that.
But none of them, I mean, they're all wishy, squeezy, squishy, that's what I'm trying to get to, squishy. I mean, they don't really, they could mean a whole lot of things.
And they were, well, no.
I think that, to answer that question, Your Honor, I think that we have to go back to what was the concern in Padilla versus Kentucky. And in Padilla, the court was concerned that a defendant pleads guilty without knowledge that his conviction now has satisfied a condition that would allow the federal government to deport him. And that's what each,
Padilla says two things, right? At one point, it says eligible for deportation. At another point, it says presumptively deportable. Those are two different
And
concepts.
the third thing, it says faces a risk of deportation. Actually, it says three things.
it does. And I
Three
think
different
that,
things and equates them.
I think that they are using those terms interchangeably because defense counsel cannot be put in a position of trying to determine what is the probability that you are going to be, that the federal government is going to initiate deportation proceedings against you. All defense counsel can do is read the statute. And in this case, the statute tells the defense attorney that as a result of pleading guilty, your client he has satisfied the condition that makes him eligible for deportation. What happens after that? Whether or not ICE agents ever, and Department of Homeland Security, ever initiate deportation proceedings is something that defense counsel simply cannot tell his client.
But now, is what a lawyer says to a client in this, with respect to the immigration consequences, is it a matter of law, precisely what has to be said, or is it a question of fact, what the average competent lawyer would have said? And what I'm leading to is, the Committee for Public Counsel Services has a manual that says, here's what you say. And what you're supposed to say is not what was said in this case, but in fact, you're supposed to tell the person that you're subject to, I think it's immediate deportation, or there's a presumption of deportation. Why shouldn't we look to the CPCS manual, in a sense, as the standard for what the reasonable practicing criminal defense lawyer should be advising their clients?
I think that the court has said that CPCS manuals are instructive, although not determinative. And in this case, CPCS has set out what is the best practices for CPCS attorneys and court-appointed attorneys. They have this immigration impact unit, which offers expert advice, and I would suggest that the CPCS amicus brief is a good example of how complicated and complex the intersection of immigration and criminal law really is. That's why they have this immigration impact unit, which has experts on immigration law to advise defense attorneys who need in the field advice. But in reality, telling a client that they are subject to presumptively mandatory deportation and subject to deportation essentially tells the client the same thing. It tells them that you have satisfied the condition. You have satisfied a condition that makes you deportable. And now, as a result, the federal government can deport you. And that's why I would suggest Padilla, at page 1483 of Padilla, the court uses those terms interchangeably because they mean the same thing. You have to alert the client that the consequence is that you have satisfied the condition that makes you deportable. What happens after that, we cannot tell you. Defense attorney cannot tell the client.
Is that because the Supreme Court didn't think very hard about the difference between the element that you're presumptively deportable if the AG chooses to proceed with deportation proceedings? I mean, it eliminated that whole first part. Will the AG proceed against you? And simply focus on the fact that if the AG does proceed against you, you will almost certainly lose.
I think that the Supreme Court did consider the fact that it is a discretionary step because it includes the language, you will be subject to deportation. You are now eligible for deportation, as opposed to you are now deportable. I'm sorry, you will be deported. And I think the Supreme Court did factor in that, and they did. I think that the language that they chose shows that this is an exercise of discretion that is exercised by the Attorney General based on a variety of factors. But what remains constant under the statute is that if you plead guilty to one of these offenses, one of these clear and succinct offenses, for which, one of these offenses for which the consequence is clear and succinct, all that means is that now you are eligible. Now you have met the condition that makes you deportable. What happens after that, we cannot have defense counsel guessing at what the current administration will do as far as how it will enforce its own immigration policies.
Isn't risk what defense counsel deals with when they're deciding whether to plead guilty? The risk of being found guilty at trial? It seems that risk is an inherent element in the calculation of whether to plead guilty, whether it be the risk of being convicted, the risk of a certain sentence, and this is just one more risk where there's a degree of uncertainty.
I think the degree of uncertainty is too great, because I can imagine a situation. I think this case presents a great example. In this case, the defendant was charged with a crime which would subject him to a minimum mandatory state prison sentence, and if convicted, would subject him to a level 1 priority under the discretionary guidelines at that time. Instead, he was convicted of possession with intent, given probation, and as a result, because he didn't have jail time at that point, he was a level 2 offense. So he had 3 factors going for him as a result. He wasn't going to jail, and jail or prison is an important factor because that's how ICE, through its CAP program, determines whether or not there are immigrations in custody.
That's how they get you.
Exactly, and so the defendant avoided that consequence here. He also was a level 2 priority, and he avoided jail time. Now, if defense counsel had said, there is a very great risk that if you plead guilty, you will be deported, or you will be deported, defense counsel goes to trial, he's convicted of trafficking, he gets the minimum mandatory 5-year sentence, and he's now a level 1 offense in jail where ICE is going to determine that he is someone who should be deported. Yeah. So I could see that claim coming back in the end as an ineffective assistance of counsel claim on that end. So and that's why we can't require counsel to make that sort of probability likelihood determination.
But if you, it seems to me that one of the problems with saying you're eligible for deportation is like saying that if you buy a lottery ticket, you will be eligible to win $16 gazillion. You know, let's jump for it. I'm going to go for that. And I mean, that gives the person absolutely no idea whether it's worth buying a lottery ticket or not. Whereas if you say you're presumptively deportable, the person has a pretty good idea what they're getting into by pleading guilty, or at least a much better idea.
Well, again, I think if you're telling someone that they are presumptively deportable, you're telling them as a defense attorney that it is likely that you're going to be deported. And again, I revert back to the Commonwealth's position, which is we can't have defense counsel telling a client based on likelihood, based on probability, based on the premise that these immigration statutes are going to be strictly enforced.
But
you tell someone...
Sorry, in Padilla, the court does distinguish in the circumstances when the consequences of the plea are unclear. And if it is unclear, then it's okay to talk about risk. But then it says, but not otherwise. So it distinguishes the risk category from the uncertain concept, from what if you don't know what you're going to get if you plead something, to something stronger than that if you do.
I agree, Your Honor, and I completely agree that's what Padilla said. But what I would suggest is what they were saying at that point is if the consequences of the crime are unclear such that counsel cannot tell the client that as a result of this crime, you are now eligible for deportation, you tell them that there is a risk that they will be deported, as opposed to conclusively telling them that as a result of pleading guilty, as a result of this conviction, you have satisfied a condition in which the government can deport you. And that's not what you're telling them when you tell them there's a risk of deportation. I
The
think
Supreme
that's the
Court says in
difference.
those circumstances, you should tell the client they may carry a risk of adverse immigration consequences.
Yes, Your Honor.
Which is much different than you're eligible for deportation, you face deportation, you are subject to deportation.
Exactly. It's far less conclusive advice.
But, you know, I was very taken with your analysis just then about this, you know, the pros and cons of doing one thing and another. Isn't that the kind of advice we want to have given, that kind of particularized, you know, if you go this way, this could happen, if you go this way, this could happen, and to have it explained in this particularized analysis, which is the kind of help lawyers give clients all the time, not just in the criminal law. I mean, you know, you're advising clients about weighing risks all the time. Isn't that really what we're looking for?
Yes, I agree with you. I think that you tell them that you lay it out for them. If you decide to go to trial, you face X, Y, and Z.
Well, you know, it could be level 2, and,
Yeah.
you know, or versus level 1, and these are the chances, and what do we do?
But I think that I'm making this argument about what what Department of Homeland Security discretionary memo says at this point to this court. But I don't think that we should require defense counsel to look into what is the current practice of the administration, what are the current policies of the administration. I think that's far too nebulous to require defense counsel to do. What is far more concrete is to tell them precisely that because you plead guilty to this crime, you have satisfied the condition, and the federal government now can deport you. That's what defense counsel did in this case. Defense counsel should be commended in this case the way he handled the proceedings that were in front of him.
I take, and the standard we're dealing with is ineffective assistance of counsel, which
That's
doesn't
correct.
mean perfectly clear, absolutely best possible ever advice.
Precisely, Your Honor, precisely.
CPCS says that the advice should also include the risk of the exclusion from admission. That is, if you leave the country, you can't come back. What's your view on that?
If I may, I see my time is up, but if I may, first of all, I would suggest that Padilla discusses only the dire consequence of deportation, not denial of naturalization, not inadmissibility once you leave the country. I find myself in not a very good position to answer Your Honor's question because, frankly, I think those are far more collateral consequences than is deportation, and I just simply haven't researched the relevant immigration statutes to be able to give Your Honor to give a concise answer. But our position is that Padilla deals specifically and only with deportation.
Great, thank you.
Thank you very much, Your Honors.
Good morning, Your Honors. May it please the Court. Eduardo Masfer, and with me, Osorio Santana for Mr. Elan DeJesus. This Court stated, not 4 months ago, under Article 12 of the Massachusetts Declaration of Rights, defense counsel has a duty to provide a non-citizen defendant with, and this was the Court's term, accurate advice regarding the deportation consequences of pleading guilty or being convicted at trial.
So what's inaccurate about you're eligible for deportation, you are deportable, you face the risk of deportation, you are subject to deportation. All of those things are true and accurate.
They're not true or accurate. It means you could stay.
Would your client have been deported if he hadn't been rearrested?
Yes,
He would have been. You can say that with a certainty.
I can.
That's very interesting.
Because as a lawful permanent
But of
resident...
course, he spent 1.5 years here and nobody
2 years.
said boo.
That's
2
correct,
years.
Your Honor. Because
Until
as
he
a-
was rearrested.
As a lawful permanent resident, you're required to apply to renew your green card every 6 or 10 years, depending on the type of card you have, where you are fingerprinted. And if you have any eligible convictions, they will come and get you.
If the
Not if.
Department of Homeland Security decides, based on its priorities, that it would be appropriate.
I don't know, Judge, because I don't work for...
Of course you don't know.
Well, that's the whole point. We're lawyers. We give legal advice. We don't guess as to how an executive agency is going to employ that legal
So
advice.
you would say, well, you will be deported.
I will say that it's not a matter of if, it's a matter of when. And this is a priority 1 offense. It's not a priority 2 because it's an aggravated felony. I don't think that...
The level 2 priority under the current administration's policies on deportation.
It is not. It is a level 1 because although a drug offense in general is a level 2, such as if he had been convicted of possession, because he was convicted of a distribution offense, that makes it an aggravated felony, and all aggravated felonies are priority 1 offenses. So that is incorrect to say that there was a difference in priority for Mr. DeJesus. There wasn't.
Could there be?
Not on this charge, unless a different
Unless the department
administration-
makes a new determination about what its priorities are.
And of course, Judge, that can always occur. But the issue as lawyers giving advice to our clients is that we have to give legal advice based on the law, not based on an agency's responsibilities to enforce that law. If I tell my client, it's perfectly fine for you to go out and kill somebody, I don't know if the police are going to catch you. Maybe they do, maybe they don't. And if they do, maybe the district attorney's office will prosecute you. Maybe they will, maybe they won't. And by the way, if you commit murder...
You
and
could be prosecuted.
You could be, you could.
you
I
could be
don't know,
deported.
but that would be the advice we would give our clients. Go out and commit murder, you're eligible for prosecution.
You could be prosecuted for that.
You could. I think that would not be effective or accurate advice. And certainly when it came time to plead that client, if I told him, if you plead guilty to first-degree murder, you will be eligible for incarceration. It's true. He's eligible for it. Maybe the clerk makes a mistake in the paperwork. Maybe there's a pardon down the line. Maybe
Very
something
different.
else happens.
That's very different. You're talking
Interestingly
about
enough,
the discretion exercised by an entirely different agency of the government.
but not the law. I agree with the court. The enforcement of it, who you pick up, when you pick them up, that becomes discretionary. And I agree with the Commonwealth. As lawyers, we can't tell them, hey, on 2 weeks from now, they're going to come get you, maybe a month from now, maybe a year from now, maybe 2 years from now.
I'll say you're deportable upon the order of the Attorney General.
Shall. It says the Attorney General, the specific statute says 8 U.S.C. 1227, classes of deportable alien, and it's on page 57 of the committee's amicus, their appendix. Any alien, including an alien crewman, in and admitted to the United States shall, upon order of the Attorney
Upon
General.
order of the Attorney General?
Yes.
Upon order of the Attorney General?
Yes.
If you were indicted, you shall be, upon order of the Attorney General, another
Yes.
branch of government?
Yes. But, Your Honor, in terms of giving
You have met the
advice-
criteria. You are eligible to be deported. You are subject to deportation upon order of the Attorney General.
that implies that you may
Should
not
that
be
be the
deported.
advice? You are subject to deportation upon order of the Attorney General?
It should not be the advice.
Okay.
The advice should be specific given the effects of given the particular charges that are confronting the client and given that client's personal background. That's how we give advice to clients. We look at their particular scenario and find the way to best advise them how to proceed. When we're talking
The standard we're imposing here is
is to give accurate advice to the
effective
client.
assistance of counsel, what we would expect from an ordinary, fallible lawyer.
That is correct.
And the advice given here, you say, is below what we would expect from an ordinary, fallible lawyer.
It is below, because the ordinary fallible lawyer would reach out to an immigration attorney, as this one did. And when he learned that it was an aggravated felony conviction, subjecting his client to automatic and certain deportation,
Upon order of the Attorney General,
it's really upon order of being arrested, because there's no discretion. The Attorney General doesn't have discretion to take an aggravated felon who's been through proceedings and say, I'm not going to physically
he
deport
has
you.
complete discretion not to seek an order, which, of course, he can do whenever he darn well pleases,
That may be
without
true.
categories he pleases.
That may be true, Judge, but I couldn't envision a scenario where I advise my client, depending on what attorney general we have, and depending on how he chooses to enforce the law in the future, you should continue with this course of conduct, or this course of conduct.
The advice isn't you should continue with this course of conduct.
The advice is that you can take this plea, you'd only be eligible. Maybe they'd come get you, maybe they won't. That's what that may implies. That eligibility implies that there's a possibility, or a significant one, that they are not going to find you, that they are not going to deport you. And it's worse than that, Your Honor, because when you're there, the ordinary person visions this scenario differently than perhaps somebody who studied the law. If I've been in this country, like Mr. DeJesus had been, since I was 11 years old, and at age 28, I am now going to be subject to removal from the United States, I would think that my 17 years in the United States, my strong ties, my family, everything would somehow weigh in my favor.
If
or
you're
certainly
subject to
give pause.
deportation, isn't that what he was advised? You're subject to deportation.
But it
You
doesn't.
just said, if I were to know that I'm subject to deportation, I would be very concerned about it.
I would.
thought that was the advice
I
he
would
was
be
given.
concerned, and I would think that perhaps there was something that could be done. But there's nothing that can be done in the aggravated felony scenario. There's no discretion. The only discretion we've talked about is the commencement of removal. The immigration judge sitting there can't say, you've been here for 20 or 30 or 40 years, I will let you remain here. Nope, you have an aggravated felony conviction, you must be removed. Any forms of relief that are available are not available to an aggravated felon. So all of those discretionary calls that a regular person might think, or perhaps even an attorney who hasn't looked into it, might think they are eligible for, they are not eligible for. Eligibility usually refers to something that's desirable. Nobody wants to be eligible for deportation, but if I'm eligible, does that mean, sort of the logical question, I'm definitely going to be deported? Or can I like maybe pitch my case to a
Advice
judge?
should be you're definitely going to be reported.
The advice should be, if you plead to this aggravated felony,
You will definitely be deported.
you will, if you want, you can caveat it with if immigration, or I would say really when immigration catches up with you, you will be automatically deported, you will have no ability of release, and you will have no ability of relief. So it's simply a permanent banishment from the United States. And that advice, Your Honor, isn't new. This court, Justice Duffy, in Maharino specifically said, conviction of an aggravated felony has the consequence of removal without the possibility of cancellation of removal. In essence, punishment for life, from a banishment for life from the country that has been the defendant's home since childhood. So it's not anything new.
He didn't know what deportation was?
He didn't know he'd be banished for life.
He didn't, so he
Mr.
should be,
DeJesus.
so deportation should be explained to him.
Yes.
And you are subject to deportation.
Is not enough.
And by the way, deportation means you're out of here for life. So that's the problem?
No,
Didn't
the problem
explain what deportation
is that there's nothing that can stop your deportation. You can't ask for help. You can't ask for relief. No factor that you would logically think would affect this will come into play.
So what if the next client comes in and says, yeah, I was told I'd be deported, but it wasn't explained to me that that means I wouldn't be able to come back into the country, or it wasn't explained to me that that would mean I would be forever banished. Is that also ineffective?
I think it depends on the particular case. If it's a possessionary offense where it's only deportation, where you're eligible for forms of relief, that advice is sufficient.
For me,
In the aggravated
problem
felony
is that
context, it does not.
Eligibility doesn't by itself convey much.
It doesn't.
Convey much to me. We seem to disagree, even on this bench,
Mm-hmm.
for those of us who've commented, the level of information that eligibility itself provides. To be eligible, is it to be eligible for a prize, which you never will get, or to be facing a very high risk that as soon as, that they will catch up with you, and that what will happen to you when they do is leaving and never coming back.
It is. And
And of course, you're talking here, as you often are in these cases, to someone who might not actually have English as their first language, let alone a level of understanding of that language that would be able to permit them to parse risk and eligibility and virtual certainty and likelihood, and you might be subject to.
It is, and they do, and a lawyer does need to explain that to them, but it's not just in the isolation, and I'm not saying you're suggesting it, but it's not just in the isolation of giving immigration advice. In Maharino, Justice Spina specifically talked about how immigration consequences may nevertheless factor into litigation strategy, including plea and sentencing stages. The immigration consequences informed trial strategy is appropriate given the great impact and involvement the criminal justice system can have on a non-citizen's immigration status. So in this particular case, in Mr. DeJesus's case, understanding that if you plead guilty to the reduced sentence,
And you don't go to jail.
you don't go to jail, but at some point immigration is going to come up, is
Versus
going to
you
catch
don't
up with
plead
you.
guilty and you might go for 5 years minimum and then be deported. So why isn't that strategy?
Because it's not. Because you could go to trial and you could be convicted of possession. For example, Mr. DeJesus's case, he only had drugs on him. If he were convicted of possession versus the distribution case that he pled to, he would be eligible for cancellation of removal. He could apply for relief. So now he's looking at a trial and saying, well, if I win my trial completely, if I'm acquitted, or if I win my motion to suppress, which he had a good one, then I have no consequence. If I go to trial and I advocate pure acquittal, I also have no consequence. If I go to trial and I say, well, they only convicted me of straight possession, then I get to apply for a form of relief.
So if you plead guilty, you face deportation.
If you place
You
guilty,
understand that. I don't want to go to jail, though. Okay, well,
That's
if you
right.
plead guilty, you face deportation.
and
And I
if-
can get you a deal where you won't go to jail.
And if immigration catches you, you're going to jail with immigration. You'll be held without bail with
I was
immigration.
told that he
and
would face
deported.
deportation if he pled guilty.
But facing deportation doesn't convey that across. And it doesn't because immigration is much larger than that. Many people are in immigration proceedings, not in custody. People who entered unlawfully. People who are simply caught for a more minor offense that doesn't subject them to automatic deportation. People in the community will know, oh, my aunt saw an immigration judge, they were looking at deportation but won their case. I have a friend of mine, my brother snuck in illegally, saw the immigration judge, and after a year and a half was granted a green card. So being subject to deportation, being placed in removal proceedings, is not the end-all, be-all. As Your Honor, I'm sure realizes, the aggravated felony in this context is what separates that. It's the aggravated felony that makes this advice wrong. Padilla did use the three terms, but they didn't use them interchangeably. Padilla's counsel counsel could have easily determined his plea would make him eligible for deportation. That's where that phrase comes up. It wasn't the advice to be given. It was that the lawyer should have realized by reading the statutes that straight possession will make you eligible for deportation. Why? Because there's relief from straight possession. What it goes on to say is that when the law is not succinct and straightforward, as it is in many scenarios, the criminal attorney need do no more than advise him that they may carry a risk of adverse. So they're setting out our standards. You should determine if, the lawyer should determine if somebody's eligible. You should look at the statute. If it's not clear, then the advice of it carries a risk, I can't tell you what the risks are, that would be fair advice. What happened here? If it was a straight possession case, then I would submit that the advice he gave would have been sufficient. But then in the very next sentence, the Supreme Court says, but when the deportation consequence is truly clear, as it was in this case, and this is talking about the presumptive deportation because it was an aggravated felony, then the duty to give correct advice is equally clear. And that's what we have to ask attorneys to do.
Nothing incorrect about this advice. You just say it's not complete.
It's misleading.
It's not
It's misleading to tell somebody that they may be deported when because it implies that they may not.
Not they may be, they're subject to the deportation, they face deportation, they're eligible for deportation.
And that doesn't tell them that there's
They
no
may be
relief.
deported. Your client was not deported until he was rearrested.
And then told once he was rearrested, there's nothing you can do about it. There's no relief from deportation. You can't ask us to cut you a break. You can't ask us anything. Any of the factors, your long residence here in the United States, the fact that you only got probation, none of that played a factor into
So
it.
at the end of Padilla, it goes, to satisfy this responsibility, we now hold, this is the holding, that counsel must inform her client whether his plea carries a risk of deportation.
Yes,
That's the holding.
yes.
And
I'm sorry, in Article 12, if that's the limit of the U.S. Constitution, and respectfully, I don't think it is, because Padilla wasn't addressing that, because Padilla only had the affirmative misadvice of you're not going to be deported, and here you was. If that is the court's view of the limit of articles of the Sixth Amendment, Article 12 goes farther because this court has said it unanimously twice, that Article 12 provides greater protection. I'm so sorry.
in anticipation of a plea, a criminal defense lawyer says to his client, I don't know anything about immigration law, you should go consult an immigration lawyer, sets up an appointment, the defendant goes and talks to an immigration lawyer, comes back, they have the plea, and the defendant says, I had an appointment with an immigration lawyer and I'm satisfied with the advice he gave or she gave. Defense lawyer doesn't know anything at all about the conversation between them. Has defense counsel in those circumstances discharged his responsibilities?
No.
So there has to be some interface between the criminal defense lawyer and an immigration lawyer if there's a referral out.
There has to be, because how can the lawyer advocate for the client's overall position unless the lawyer, him or herself, understands all the levels of consequence involved?
So the responsibility is on the shoulders of the criminal defense lawyer.
It is. The lawyer, he or she, is the one who's charged with the constitutional duty, not the court in terms of giving advice, but the lawyer in terms of researching, finding the answer, and giving it. It's good, as Attorney Morano did here, to go out and get the advice, but then he has to relay it accurately back to his client.
How do we know he didn't, by the way?
Because he didn't tell his client that as an aggravated felony, he would be.
Maybe the immigration lawyer didn't tell him that. How do we know all that?
The record, nobody asked, going farther. Attorney Self is a very capable immigration attorney. Personally, I couldn't imagine her not saying that.
Oh, your client will face deportation. Okay, well, you will face deportation.
So finish this sentence. Counsel is effective with regard to immigration advice when counsel
Gives accurate, the standard the court laid out, accurate advice as to the consequences that his either plea or decision to go to trial will have on the defendant's immigration status.
not risk consequences.
Not risk.
So you agree with Mr. Hillman that the issue of risk is not appropriate?
I agree, because the only risk that we're talking about, and as Justice Cordes has mentioned repeatedly, is the enforcement action by the law enforcement branch, which nobody can control, nobody can predict. And as lawyers, we're not asked to predict how somebody will act. We're asked to give advice on what the law states. And the accurate advice for an aggravated felony is you will be automatically and certainly deported from the United States whenever they come for you, and that you'll have no form of relief eligible for you. In other circumstances, that may not be the advice. I wouldn't want the court to think there's a magical.
So you're saying basically, if they come for you, you will go.
Yes.
without evaluating what the risk is that they will come for you?
Yes, I think you can tell them truthfully and honestly, if you're a lawful permanent resident, when you renew your green card and they fingerprint you, that's a time. If you ever leave the country and re-enter, lawful permanent residents, not U.S. citizens, everybody else is fingerprinted at the border. A huge group of people are stopped that way. Of course, people who are incarcerated. Even if you're not incarcerated, he was stopped for a motor vehicle offense. We know secured communities through the CPCS brief will set your name over. So even if they don't grab you for this case, at some point in one of the various levels of enforcement that they do, there's I wouldn't say high likelihood they're going to get you. I tell my clients they are going to. And so when you make your decision, plea, trial, one version of a resolution or another, for that client to make that decision and for that lawyer to give that Sixth Amendment constitutional and Article 12 responsibility to effectively advise your client as to what to do, you need to give them not a speculative, wishful thinking that they may not get you. You need to tell them, when they do, these are your consequences.
All right, thank you, counsel.
Thank you, Your Honors.